Good morning and welcome to the David and David on Real Estate podcast. Today we are on episode number 138. David Corman, such a pleasure to be chatting with you again.
Always a pleasure, and love doing these podcasts with you, David. And sometimes we talk about trends in the real estate market, tips, advice for real estate agents. Sometimes we get into more legal issues. Sometimes like I don't have much to contribute. I'm just listening to you. Sometimes we get into topics where it's a little more up my alley, because we're discussing legal issues or things that come up in transactions. But it's always interesting, always entertaining. We always learn from each other when we do these podcasts.
We do, and I thoroughly enjoy these. I have to say, yesterday I when I was coming up with the itinerary for the podcasts, I actually went through the whole list and I went back to the very beginning and I looked at all the podcast topics and I went through every single one, and boy, did it bring back a lot of memories, and some of the guests that we've had on, I completely forgot that we've had some of these people on the podcast. We've been doing this for a long time, and I just want to say how grateful I am for all the time and your support, and you really being a part of this. It's been absolutely amazing.
Well, thank you. I appreciate that. And it's absolutely mutual, and these podcasts are reciprocal. I appreciate you coming up with these great topics and itineraries all the time. And every time you come up with these things and suggestions, I get excited about it. I go, yeah, that's a great thing to talk about. Or, you know what, I don't know anything about that. I'm looking forward to hearing what David's going to tell me about this, or the guests. But there's always something new, and then it's interesting to go back and see how much ground we actually have covered. Through 100, this is our 138th podcast. So it's a lot of ground, and then some things come back because things become relevant again, or more, the market's shifting, the market shifts, so we're repeating certain things but in a different climate, a different atmosphere. So um, and today what we're going to talk about is one of those things that's been around since episode one, and we've talked about it at different times, and it keeps coming up because it's part of what people have to do when they're, whether they're buying a property for personal use or whether they're buying a property for investment purposes. They have to understand some of the basic ways you hold title and the advantages and disadvantages. So that's a bit of the focus for this podcast. We're going to talk about what it means to have title in a joint tenancy, and the significance of that, and how that has to be an important factor in anybody's decision when they're going to own real estate.
David, I feel like there's a bit of history here. When did joint tenancy come into effect, and any idea of why the government chose to um, enshrine this into our way of transacting properties?
Well, I can't pinpoint an exact date or anything on it because it's been around forever, but it's not really something that's just involved in real estate. Okay. The concept of joint ownership applies to anything. So just to take us back, just to explain a little bit, in real estate, there's two ways that people can own title. If there's more than one person on title, they're either holding it and owning, they're registered as joint tenants. That's the legal term, joint tenants. And the word tenant has nothing to do with landlord and tenant, just a legal term, joint tenant, joint tenancy. And the other one is tenants in common. And the difference is what happens when you die. And these example, let's say it's, you and I, well, let me give you a better example. Me and my wife, because it's easier to understand it when it's a couple, a married couple, let's say. So we can own property as a joint tenant, joint tenancy. So that means there's an automatic right of survivorship. So if I pass away, my wife automatically is the owner. She doesn't have to do anything because we own it jointly. It's the same thing if we have a joint bank account. Okay. If it's a joint, anything that's joint, that's why I'm saying it's not a real estate concept. You can own a bank account jointly. You can own an investment account jointly. When the first person dies, when you own it jointly, there's an automatic right of survivorship. It automatically goes to the survivor. So it's no different in real estate. Okay. So there's advantages in owning it that way because number one, nothing has to happen. The survivor just gets the property. Legally, they're the owner just upon the death of the first person. There's that advantage. And there's also advantage of not having to go through a process to transfer that property. So just by way of the other example, if we owned the property as tenants in common, which is the other legal term, and again, tenants got nothing to do with landlord and tenant, just a legal term, tenants in common. My wife and I can own it as tenants in common, and it means we each have a percentage ownership in that property. It might be 50-50, it could be 90 and 10, it could be 99 and 1, it could be whatever people decide to own it. But the difference is, let's say we did own it as joint, as tenants in common, 50-50, and I die, my 50% interest does not automatically go to my wife. It goes to my estate. So if I have a will, my will says who that 50% interest goes to. It might say it goes to my wife. I may have a will say when I die, everything goes to my wife. But now she's got to go through a process of that probate process and filing the will in the court office and paying the government an estate administration fee based on the value of that home and pay the government a fee for that in order to be able to transfer the title of that 50% interest back to my wife. So in certain circumstances, it makes sense to own property as tenants in common. And in a lot of circumstances, it makes way more sense to own it on a joint tenancy basis. So we always have to look at it on a case by case basis to determine what the situation is and what's best for those people.
And David, there's certainly a lot of advantages. The simplicity of not having to go through probate and survivorship is huge. Are there any disadvantages of joint tenancy?
Um, yeah, it depends on where you are in life. So I can give you one simple example in my personal example. Our home, our matrimonial home, has never been in my name. Even though I'm a lawyer and I know that if God forbid something happens to my wife, I would want it to automatically come to me and not pay probate fees because I'm in business and have the potential for being sued if I do something wrong. If I own assets, it exposes potential liabilities to me on a personal basis. So the advice I got way back when was no, let your ownership of your assets should be in your wife's name, and that'll insulate you from any potential liabilities. Now, we've been married 43 years. I've never been sued and it's never happened, but the reality is it's still in my wife's name. Now, at some point, when I'm thinking about retirement and stop practicing law, we will transfer the title from her to the two of us to create that joint tenancy and get rid of that risk. So there's certain decisions sometimes you make for other reasons, okay? Because otherwise joint tenancy would make perfect sense in our situation. And at some point we're going to get back to that and we will transfer it to that. So, joint tenancy for a lot of married couples makes absolute sense. You want that opportunity when the first of you happens to die, that it's an easy process to get that matrimonial home, or it might be an investment property too, but just whatever the assets are to get it in the hands of the second surviving spouse. Okay. Now, what some people are trying to do with the concept of joint tenancy to avoid those probate fees is, well, let's say you own a property yourself, you've got adult children, you're getting older. Should I transfer the title to add my adult children who eventually will inherit from me anyways? So should I just transfer it to them now or add them as joint tenants so that when I die, they automatically get it and they don't have to pay probate fees and go through that process? So, that's a great concept of estate planning, right? And I know, David, you've got clients and that think about doing that, and it's a great thing. And we get asked all the time. And for many people, that's what we'll do for them, but not for everybody. Because if you do that, you add your adult children to your title, depends how old you are, and depends what your lifestyle is, and it depends on your relationship with those adult children. Because the reality is, if you decide, oh, you know what, I want to sell my principal residence and travel the world, go on a cruise ship and live. I want to go and I want to go live in Florida. I want to, whatever. You can't sell that property unless you get the consent of your adult children who can say, no, 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 it's not a good idea. Or I want to get a mortgage and just take out money because I want to travel. I want to get a reverse mortgage. You can't do any of that. You can't refinance. You can't do anything without the cooperation and consent of those adult children that you've now added as joint tenants. So you've got to be careful in doing it. So, and I, talk to people all the time. They're company in their 40s. No, 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 don't do it now. Your kids are, they're barely of legal age, too young. You don't want them controlling your life. When I'm 60, maybe let's talk about it. If you get into, your 70s or 80s, at some point it makes a lot of sense to do it. When your lifestyle is clearly defined, and as long as you've got a good relationship with your adult children, because you don't want them running your lives because you're trying to save paying the government some probate fees.
Yeah, and we all know those relationships change and they're fluid with time. So
Mhm.
sometimes you have to be careful when you give that sort of advice. And are there trust documents you could sign with family that um,
Yes.
can mitigate some of those risks?
Yeah, and that's a great point, David. So that's what we try to do a lot of times. So we did one just, for example, a while ago. We had an elderly lady who had a couple properties, one like her principal residence, one was like a cottage property, wants to transfer title to add her adult children to it just for these purposes. So we did that, but we also did a trust agreement at the same time to make it clear that the adult children, even though they're going on title as joint tenants, they're really going on for estate planning purposes. There's nothing wrong with that. There's nothing wrong with stating that in the trust. You're allowed to do that. And made it clear in the trust agreement that they will do whatever their mother wants them to do with the property. They'll, if she wants to sell, they'll sell. If she wants to refinance, they'll go on with it, because really they're holding their joint tenancy interest in trust for their mother during their lifetime, with the intent that as soon upon the death, they now are the owners of the property. Nothing has to be done. They own that real estate without doing anything. We don't need the will to transfer the title to them, so they save those eventual probate costs. It's not even, we the common term is probate, but it's a state administration tax. Um, so they'll save that. So that works. Okay. If you do that trust document with it to make it clear that the mother's still supposed to maintain control. So if there is a dispute, it's easy to hold that up. If you have to drag one of your adult kids to court, obviously terrible process, but any judge is going to enforce that. Here's the trust agreement. You're really holding this in trust. Your mom wants to sell the property. You have to sign and agree to the sale of that property. You agreed to do that in the trust agreement.
Yeah. Would you
And in
go what
consideration of that, you're going to get a benefit down the road upon her death because you're going to save in probate fees.
right? Would you go one step further and also maybe get a power of attorney in favor of the mother on for the purpose of dealing with that real estate asset?
Yeah, you could do that as well, and have it would be a limited power of attorney just for that specific asset. So the mother's got complete control over it. Um, we've done that on occasion. Sometimes we don't really have to go that far, but I get to the point sometimes if we're that concerned
Right.
about the adult children screwing up, then there's a problem in the relationship, and maybe we shouldn't be doing this.
Fair
And
enough.
then I go back to, I say, look, how much is this condo worth? If it's $1 million, what you're potentially saving is roughly $15,000 in probate fees. Sometimes it's just not worth it to do that. They have to bite the bullet on the probate fees when they come, because it's not worth losing that control just to potentially save $15,000. No one wants to throw away $15,000, but that's what it basically is on $1 million asset. If it's a $500,000 condo, it's $7,500. So for $7,500 savings, but there's legal costs in doing these documents and setting it up. So you're spending a couple $1,000 to get this set up. So you may not even be saving $7,500. You're saving $5,000 or something. Like, is it worth the risk to try and save $5,000? So we don't want to pay the government if we don't have to. But at some point, it sometimes makes sense. You know what? It's just not the right situation or the right timing.
That's an excellent point. I love your analysis of that, and I completely concur. I think you're right. If you have to go that far, then this probably whole situation doesn't make sense, and you're probably going to alienate your family and cause a lot more headaches than the good that you do by saving $15,000. Completely agree.
Yeah. And we've had many situations where we're not even adding all of the children or the adult children to a title. Sometimes there's one child that's more involved with the financial affairs and helping an elderly person. And it's just, we got to be careful with that too. So, no, no, just add me, not my siblings. So we got to make it clear that even if we're doing that, we're doing it for estate planning purposes. So that interest that they get upon the death of the parent isn't really theirs. Even, on title, they own it. But we want to have that other document saying, well, when you inherit that from your mom or become the survivor that gets it, you're really going to be acquiring that in trust for your other siblings and anybody else that's supposed to share under that will. Okay. So you're really in a trustee position. So we have to make sure we're doing the right legal documents with this to make these things work. So what can I tell you, David? It's a case by case thing that we do. But you have to look at this. It's a great opportunity. And you have to decide whether it's an investment property or it's your principal residence. How you take title is a crucial factor from day one.
Awesome, David. Well, listen, if anybody has any questions, they should be reaching out to your office. You guys deal with this all the time, and you're in a situation where you can absolutely help. Guys, thank you very much for tuning in. This is a pleasure, David Korman. And don't forget to subscribe and tune in for the next episode of the David and David on Real Estate podcast. Thank you, everybody, for joining us.
Okay. Thanks, David. Thanks, everybody else.
Bye-bye.